The next strategy I wanted to cover today is really something that's quite peculiar to the lawyers and the way they address they employ their legal language. And I guess one of the most common problems identified in the textbook is that lawyers tend to convert the verb into a noun in their sentences a lot. So rather than saying, we agreed to build a house, lawyers will often say, we reached an agreement to build a house. You see, the word agreement here is used as a noun, but the noun comes from the word verb to agree. Linguists will tell you it's much better to use the actual verb to convey action rather than this noun that's been converted from a verb. I'll give you another example. Instead of saying we considered the facts of the case, the courts will most of the time say we took the matter into consideration, using the word consideration, a noun, converted from the verb to consider. But what's the effect of this practice? It's a problem, because if you think about it, the word consideration is an abstract noun. It's not something you see in the nature. It doesn't convey meaning as forcefully as the actual verb to consider. We considered it. And so, it's a name, when we use these nominalizations, it's called a nominalization, we are using nouns that are abstract. And as a result, these words, they're actually names of processes. And they don't sound very lively. It sounds like nothing is going on in the sentence. We had a discussion about the issue. Sounds like we had a cup of tea. But when we say we discussed it, it's much more forceful, because the verb to discuss is used quite forcefully and quite clearly. And let me give you a further example of this practice from some jury directions. I'll give you an example from one of the textbooks. Ladies and gentlemen of the jury, says the judge, conviction of the defendant requires a proof beyond reasonable doubt. That's the instruction to the jury. What's the problem with that? Well, we use this abstract noun, conviction of the defendant, conviction. We didn't use the verb to convict. As a result, we didn't actually specify who is supposed to convict in the first place. So, using verbs instead of nominalization, conviction, the verb to convict, would force you to actually specify who is supposed to convict. And indeed, the jury direction would be much more comprehensible to the jury. You, the jury, ladies and gentlemen of the jury, in order to convict the defendant, you must be satisfied beyond a reasonable doubt that the prosecution has proved their case. So this is an example where you can see that the use of the nominalization, conviction, instead of the verb to convict, made it a bit more difficult for the jury to work out whether indeed they knew what they were supposed to do. And Professor Tisma cites several studies, empirical studies of the juries, which basically show that the average jury could not understand more than 30% of what these directions were requiring them to do. And in California, for example, the Judicial Council of California decided to rewrite these jury directions in plain English, and follow-up studies later showed that plain English instructions were much more easy to understand and that the jury comprehension was much greater. It's a serious matter indeed, because juries, after all, are supposed to convict, or acquit people, and it could be very serious charges. Just to highlight this issue once again, let me point this out. There's another jury direction that I wanted to bring to your attention. Ladies and gentlemen of the jury, says the judge, failure of recollection is a common experience, and innocent misrecollection is not uncommon either. Failure of recollection and innocent misrecollection. In both cases we have examples of the use of nominalisations, and rather strange terminology. What does that all mean, failure of recollection? Well, the words failure, recollection, misrecollection are all nouns derived from the verbs to fail, to collect, and to misrecollect. But more importantly, why did we use the word recollect when we could have used remember? And also misrecollection doesn't exist in most dictionaries. So how do we rewrite this jury direction? Professor Tisma suggests the following. Ladies and gentlemen of the jury, when considering the evidence, please take into account that people forget things, and even though they may honestly believe that something happened, it may turn out that they were wrong. That's what this jury direction was all about.